So, good morning, everybody, to this side event on combating torture and abolishing the death penalty in the OSCE region, two sides of the same coin, co-sponsored by the Norwegian Ministry of Foreign Affairs, the European Union, Government of Andorra, the Permanent Mission of the Republic of Serbia to the OSCE and other international organizations, as well as the Ministry of Foreign Affairs of the Republic of Kazakhstan. We have a distinguished panel of 4 with us today, but you can't see the 4th one because it's actually a video message. And the video message comes from Juan Mendez, the UN Special Rapporteur on torture and other cruel, inhuman and degrading treatment or punishment. I believe Mr. Mendez needs no introduction, separate introduction. We have all heard his very comprehensive and powerful remarks at the introductory session yesterday at the SHDM. I would like to start with this video message, and maybe if during that time you still need to get your breakfast, coffee or so on, please feel free to do so, and then we will proceed with our panelists, whom I will introduce at that stage. So Michael, if I can please ask you.
Distinguished panelists, ladies and gentlemen, I would like to thank the organizers, and in particular the Permanent Mission of Norway, for inviting me to this important panel. Although I unfortunately cannot be physically present, I am grateful for this opportunity to contribute to the discussion through this video statement on the death penalty and its relation to the absolute prohibition against torture and other cruel, inhuman or degrading treatment or punishment. Today, while international law supports the abolition of the imposition of the death penalty, it does not mandate states to abolish it. However, there is a clear trend towards the abolition of the death penalty worldwide on the basis of human rights law, and therefore it is of significant importance to frame the debate about the death penalty from the perspective of human rights. I am therefore grateful for the opportunity to present the findings from my thematic report on the practice of the death penalty from the perspective of the right to personal integrity and the absolute prohibition of torture and other forms of cruel, inhuman or degrading treatment or punishment. It is in this context that I would like to remind stakeholders that the prohibition of torture and other ill treatment, as enshrined under Article 7 of the International Covenant on Civil and Political Rights and Articles 1 and 16 of the Convention Against Torture, is absolute and non-derogable, and therefore does not admit exceptions. In this sense, any time that, under the appropriate circumstances, the death penalty is deemed to constitute cruel, inhuman and degrading treatment or punishment or torture, it is contrary to international law. The exception of legal sanctions that is found in the definition of torture of Article 1, Paragraph 1 of the Convention Against Torture cannot be read, as many have claimed, as an exception for the death penalty. A sanction that is illegal under international law cannot be made legal by domestic laws. In my 2012 interim report to the General Assembly, I presented my findings, which demonstrated a growing dilemma between international jurisprudence and national courts with regards to the actual application of the death penalty and its contradiction with the prohibition of torture and cruel, inhuman and degrading treatment. The premise of my report was the need for a new approach to frame the international debate about the legality of the death penalty within the context of the fundamental concepts of human dignity and the prohibition of torture and cruel, inhuman and degrading treatment. This approach is demanded by an observable global trend in regional and domestic jurisprudence and state practice increasingly to consider that the death penalty can amount to ill treatment or even torture under some circumstances involving the death row phenomenon on the one hand and certain methods of execution on the other. Despite the global trend towards the abolition of capital punishment, some states continue this practice. The death penalty does not constitute a violation per se of the right to life if it is imposed and executed in accordance with severe restrictions and safeguards provided by international and domestic law. Unfortunately, states such as Belarus, India, Kuwait, Nigeria, Vietnam, and Indonesia, which had not carried out executions for a period of time, have resumed the use of the death penalty. In the United States, 32 states, as well as federal civilian and military courts, retain the death penalty as possible punishment for certain criminal offenses. Of increasing concern is the number of death penalty sentences imposed by authorities in Iran and Iraq that have resulted in a sharp global spike in the number of executions carried out in 2013, bucking the global trend towards reduction and eventual abolition. However, these figures of 2013 do not undo the overall progress already made towards abolition. According to recent figures presented by Amnesty International, at the end of 2013, 98 countries have abolished the death penalty in law for all crimes, and 140 countries have abolished the death penalty in law or in practice. States are obliged under international law to uphold the absolute prohibition of torture and of other cruel, inhuman, or degrading treatment or punishment. In practice, executions can violate the absolute prohibition, either because of the death row phenomenon or because the methods that are applied to execute involve unnecessary suffering and indignity. In light of new forensic evidence and discussions among experts concerning the various forms of execution and the situation of persons sentenced to death and awaiting execution, states should give serious reconsideration of whether the actual practice of the death penalty amounts to cruel, inhuman, and degrading treatment or even amounts to torture. To start with, specific methods of execution and other circumstances related to the implementation of the death penalty often constitute violations in and of themselves. This understanding is reflected in state practice and international, regional, and domestic jurisprudence. In my report, I determined that several methods of execution, including stoning and gas asphyxiation, have been explicitly deemed to violate the prohibition of torture and cruel, inhuman, and degrading treatment by international and domestic judicial bodies, and have been prohibited by a number of retentionist states. The United Nations High Commissioner for Human Rights has also found hanging to present a real risk of ill treatment. Several high courts and UN treaty bodies have also closely scrutinized other methods such as lethal injection, and have found that it cannot be empirically supported that in every case this method complies with the prohibition of torture or ill treatment. The Human Rights Committee, for instance, has called on the United States, where lethal injection is mostly used, to review its execution methods in order to prevent severe pain and suffering. This method of lethal injection, as currently administered, does not work as effectively as intended. Some prisoners take minutes to die, and others become very distressed. Although the U.S. Supreme Court has rejected this argument in the case called Bays et al. Versus Rees, a 2008 case, new studies indicate that even if it is administered without technical error, it may induce painful suffocation, which in occasion is only disguised by the paralytic agent that is used in the injection. In my report, I found that it cannot be empirically supported that in every case these methods of execution comply with the prohibition of torture and cruel, inhuman, or degrading treatment. The fact that a number of execution methods have been deemed to constitute torture or CIDT, together with a growing trend to review all methods of execution for their potential to cause severe pain and suffering, highlights the increasing difficulty with which a state may impose a death penalty without violating international standards. Methods either involve unnecessary pain and suffering, or we have no way of establishing that they do not. The second situation, where the death penalty may lead to a violation of the prohibition of torture or CIDT, is the so-called death row phenomenon. The death row phenomenon is a relatively new concept, albeit one that has become the subject of international jurisprudence. It consists of a combination of circumstances that produce severe mental trauma and physical deterioration in prisoners under sentence of death. Those circumstances include the lengthy and anxiety-ridden wait for uncertain outcomes, isolation, drastically reduced human contact, and physical conditions and regime restrictions which are often worse than those for the rest of the prison population. In Soring versus United Kingdom, the European Court of Human Rights has held that prolonged periods of time spent on death row awaiting execution violate the prohibition of ill treatment. This decision, however, was based not only on the length of time spent on death row, but also on the personal circumstances of the inmate, including age and mental state. The Inter-American Court of Human Rights and the Inter-American Commission on Human Rights have similarly held that prison conditions, together with the anxiety and psychological suffering caused by prolonged periods on death row, constitute a violation of the prohibition of torture and ill treatment. This is not to say, however, that if states were to carry out a capital sentence as expeditiously as possible, the risk of ill treatment would be avoided. The lengthy wait for execution is in many cases tied with the availability of legal recourses and remedies compatible with the demands imposed by due process, which also point to the increasing difficulty of states to apply the death penalty without violating other important principles of international human rights law. Solitary confinement is one of the most common practices used on death row. In my 2011 interim report to the General Assembly, I examined the effects of prolonged and indefinite solitary confinement. This practice, in combination with the foreknowledge of death and the uncertainty of whether or when an execution is to take place, contributes to the risk of serious and irreparable mental and physical harm and suffering to the inmate. In addition, death row prisoners constantly face unimaginable anxiety over their own imminent death. Additional circumstances, including a lack of notice as to the date of the execution, secret or public executions, and mistakes in administering the execution, increase the mental trauma of persons sentenced to death. The anxiety and foreknowledge of death affect the mental integrity of a person sentenced to death and can amount to torture or cruel, inhuman, and degrading treatment. I find that while international human rights bodies have yet to take the step of holding the death penalty per se as going against the prohibition of torture and cruel, inhuman, or degrading treatment, there is clearly a trend in this direction at both the regional and national levels. Especially relevant to the debate is whether a customary norm to consider the death penalty as being contrary to this prohibition of torture and CIDT is developing or emerging or is already upon us. It is worth exploring if a consistent practice by a vast majority of states reflects the view that the imposition and enforcement of the death penalty in breach of recognized standards and legal safeguards is a violation per se of the prohibition of torture and or CIDT. Consistent state practice with a sense of obligation would amount to a customary international law obligation. In fact, international law already expressly considers the death penalty to be a violation per se of the prohibition of torture or ill treatment when carried out against juveniles, persons with mental disabilities, pregnant women, elderly persons, and persons sentenced after an unfair trial. Also, an increasing number of regional and domestic courts, including the Inter-American Court of Human Rights and the United States Supreme Court, have held that the mandatory death penalty, where judges have no discretion to consider aggravating or mitigating circumstances with respect to either the crime or the offender, violates due process and amounts to ill treatment. These findings are reinforced by the fact that international law does not attribute different values to the right to life of different groups of human beings, such as juveniles, persons with mental disabilities, pregnant women, or persons sentenced after an unfair trial, but in fact considers the imposition and enforcement of the death penalty in such cases as particularly cruel, inhuman, and degrading, and in violation of Article 7 of the Covenant and Articles 1 and 16 of the Convention Against Torture. In analyzing this issue in my report, I concluded that there is an evolving trend within international bodies which is also supported by robust state practice and regional and domestic jurisprudence, to consider the death penalty a violation of the prohibition of torture and ill treatment, regardless of the methods or circumstances of the execution. In my opinion, this trend is evolving, if it has not already emerged, into a norm of customary international law. It is important to keep in mind that from the perspective of international human rights law, conventions are living instruments and need to be interpreted in light of present-day conditions. With this understanding, the notion of torture has developed over time, and acts originally considered lawful have become unlawful and prohibited under the right to be free from torture. As recognized in international jurisprudence, the definition of torture needs to evolve with a democratic society's understanding of the term. A new approach is therefore needed to frame the debate about the legality of the death penalty within the context of the fundamental concepts of human dignity and the prohibition of torture and cruel, inhuman, and degrading treatment. Even if the emergence is still underway of a customary norm that considered the death penalty per se as contrary to the prohibition of torture and CIDT, most conditions under which capital punishment is actually applied today render the punishment tantamount to torture. Under many other less severe conditions, it may still amount to cruel, inhuman, or degrading treatment. It may still be theoretically possible to impose and execute the death penalty without violating these absolute prohibitions. But the rigorous conditions that states must apply for that purpose, as well as the rigorous conditions of fair trial and due process and seriousness of the crime that are also restrictions on the death penalty, make retention of capital punishment costly and impractical and not worth the effort. Even with such conditions, states cannot guarantee that in all cases the prohibition of torture will be scrupulously adhered to. Based on the global trend towards abolition, and although my report did not aim to determine the existence of a customary norm, I firmly believe that a rule of customary international law that prohibits the death penalty under all circumstances because it violates the prohibition of torture and ill treatment is at least in the process of formation. States need to re-examine their procedures under international law because their ability to impose and carry out the death penalty is diminishing as these practices are increasingly viewed to constitute torture or other cruel, inhuman, or degrading treatment or punishment. Distinguished panelists, ladies and gentlemen, I thank you for your attention, and I wish you a very interesting panel discussion.
So if I may take just a minute or two to summarize the main points of such eminent expert as Mr. Mendez, also perhaps for the benefit of those who have joined us in the course of his presentation. Mr. Mendez recognizes that the death penalty is not illegal as such under international law. Indeed, the right to life provision does not prohibit the death penalty or recognizes the possibility of the death penalty. However, the very elaborate and interesting argument that he makes is that it is the prohibition of torture which may render the death penalty illegal under international law, and if something is illegal under international law, it cannot be made legal under the domestic law. He says that while in theory it may be possible to execute a person without inflicting suffering and indignity, in theory, in practice, as his experience has shown and other research has shown, this appears not to be possible. There is a couple of reasons for that. One relates to the methods of execution, which in and of themselves may constitute inhuman and degrading treatment, if not torture outright, but also the so-called death row phenomenon, which creates a range of issues, and it has been recognized by a number of courts. We will hear about that a little bit later, in terms of the solitary confinement, which usually accompanies the carrying out of a death penalty, and the due process safeguards, which may not have been fully respected in the process of adjudicating the death penalty. So his question at the end is twofold in a way. He's asking if a customary law norm may be emerging in this regard, and he seems to be thinking along those lines. Given the state practice and the sense of obligation the states have displayed in addressing the issue of the death penalty and dealing with it. He also asserts that such norm has already emerged in the cases of execution of juveniles, people with mental disability, pregnant women, older people, and in cases of unfair trial. But he also, his second point, I think, is that he flags the issue of conventions being living instruments, and conventions that need to be read in the context of the time and that evolve as the society evolves. And he's asking then, you know, should the definition of torture evolve in this regard so that it would cover fully also the situations of executions in the context of capital punishment. I mean, another perhaps more trivial example, we know that corporal punishment of children in schools is no longer considered acceptable. In fact, it is considered to constitute inhuman and degrading treatment, and this has been an evolution over time, for instance, just to give you an example. Now, in the OSCE context, this argument becomes a bit more complex, if I may. The OSCE commitments on the prohibition of torture are clear, unequivocal, and comprehensive. Prohibition is absolute, and prohibition of torture is absolute and non-derogable, and the states have committed to that and recognized this fact in various forms on 9 occasions in various OSCE commitments, from Vienna in 1989 to Athens in 2009. And perhaps it is to be hoped that something similar can be achieved at the Ministerial Council in Basel as well, in the connection to the prohibition of torture. However, in the context of the death penalty, the situation in terms of the OSCE commitments is less clear. In Vienna in 1989, the states have agreed to impose the death penalty only for the most serious crimes in accordance with the law and not contrary to their international commitments. In Copenhagen in 1990, they then acknowledged the relevant international law provisions applicable to the death penalty. They noted the activities of NGOs related to the death penalty and committed to exchanging information related to the question of the abolition of the death penalty, to keep this question under consideration, and to make public information regarding the use of the death penalty. Interestingly, this is where ODIHR's work on the death penalty, which namely consists of producing an annual report of the situation concerning the death penalty in the OSCE area, comes about, and it is published annually during the Human Dimension implementation meeting, based on the information provided by the states who still either retain the death penalty on the books or practice the death penalty. Now, I guess the question here a little bit is, why is the death penalty mentioned at all? Especially in the context of abolition, does this perhaps imply that the death penalty might be desirable, although it is not required? So I would like to stop here and turn to the panel, because indeed we have, again, I have the pleasure of sitting among a very distinguished group of panelists. To my right is Ms. İoanna Kuçuradi, who has a distinguished career in teaching and human rights over several decades. It started as far back in 1965 at the Atatürk University in Erzurum. She also lectured and taught at the Hacettepe University in Ankara, and also at the Maltepe University in Istanbul, where she was appointed professor of philosophy and director of the Center for Research and Application of Human Rights. Ms. Kuçuradi is also holder of a UNESCO chair on philosophy and human rights since 1998. She is a member of several associations and bodies, such as the Afro-Asian Philosophy Association, the High Advisory Council for Human Rights in Turkey, and the International Academy of Humanism. Now, further to my right is Mr. Childerik Schaapveld, and I don't think he requires a particular introduction. We all know, most of us actually know him as the permanent observer of the Council of Europe to the UNODC and other international organizations in Vienna, including the OSCE, since 2011. Prior to that, he was the director for democratic institutions at the Council of Europe in Strasbourg, and of course, as far as the ODIHR mafia is concerned, Childerik was there as well. He was the NGO advisor with the Office for Democratic Institutions and Human Rights in the OSCE between 2002 and 2009, I take it. So one of ours, if I may. And finally, to my left at this time is Mr. Nicolas Perron, who is the program director for ECPM, which is the French organization Together Against the Death Penalty, and I will spare you my French pronunciation. Together with ECPM local partners, he develops campaigns for lobbying the government and international organizations, implements capacity building projects for national and regional coalitions against the death penalty, and organizes activities for abolition education. And we'll be hearing a little bit about that a little bit later. I would now like to turn to you, Ms. Kuçuradi, for your presentation, please.
Thank you, Madam Chairman. On behalf of the International Commission Against Death Penalty, I wish to welcome all of you to this event. Our commission was established on October 7, 2010, at the initiative of Spain, and is supported by 18 countries and an efficient secretariat. It consists of 50 members, including an honorary member, who are well known for their work on human rights. It is chaired by Federico Mayor, former Director General of UNESCO. Its objectives are to promote the abolition de jure of the death penalty, and until this is achieved, to promote the establishment of global moratorium. To this end, the Commission calls for the suspension of executions, undertakes missions to select countries, makes statements and appeals related to death penalty, participates in relevant meetings like the present meeting, and thus tries to contribute to the cause. Dear friends, if from the right to life is understood the demand not to touch or violate the physical and mental integrity of a person, then it is not difficult to see that both the death penalty and torture violate this right. Yet, if we look at our main human rights instruments, we are faced with a strange fact. A state that applies the death penalty violates the right to life, but not Article 6 of the Covenant on Civil and Political Rights, as it was already said, which, after stating that every human being has their inherent right to life, adds that no one shall be arbitrarily deprived of his life. And continues as follows: in countries which have not abolished the death penalty, sentence of death may be imposed only for the most serious crimes and in accordance with the law in force. This is an obvious bargaining on the right to life, and is in discordance with the following Article 7 on torture, which states that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment by any state party to the present covenant. In this article, there is no compromise. The death penalty is an inhuman punishment. This is perhaps the reason why the attempt is made to connect the death penalty to torture. This is legal acrobatics in the fight for the abolition of death penalty. We have to go to the core of the matter and make obvious why the death penalty is most serious violation of the right to life, which cannot be justified in any way by positive law. That is, by laws formulated by taking as their base human rights, not by taking as base human rights, but other, mostly cultural norms and considerations. The Charter of Fundamental Rights of the European Union, adopted in the year 2000, in spite of the fact that it repeats various problematic points of the previous instruments, can contribute a legal basis for further development. Article 1 of the Charter states that human dignity is inviolable. It must be respected and protected. And Article 2 on the right to life states that everyone has the right to life. No one shall be condemned to death penalty or executed, quite openly. Dear friends, in the light of this consideration, I shall briefly give one or two reasons why the death penalty should be globally abolished, and subsequently I shall try to answer the questions of the draft proposal of our meeting. The death penalty is mostly imposed on criminals who have committed murder. That is, certain human beings are condemned to death because they caused the death of other human beings, because they killed other human beings. If this is the case, to condemn someone to death is to commit exactly the same act which considered to be a crime. Is this not transforming law into means of revenge? Presently, in many states, we often see enforced laws which are in discordance with human rights. Human rights are, first of all, ethical principles, not to forget this. And for this reason, they have to constitute the basis of all law. Otherwise, it is possible to violate human rights without violating the relevant law. It is even possible to commit a crime by using law, as is the case with the death penalty. Thus, in connection with the first question in the draft proposal, which this panel is expected to address, that is, whether a state violates international commitments relating to the right to life and prohibition on torture when it continues to apply the death penalty, I would say the following. A state which continues to apply the death penalty does not violate Article 6 of the Covenant on Civil and Political Rights, yet it violates Article 7 of the same covenant, which states no one shall be subjected to torture. Death row is obviously, as was already said, a mental torture, or to cruel, inhuman, or degrading treatment or punishment. The death penalty is indeed an inhuman punishment. A state that continues to apply the death penalty also violates Article 2 of the Charter of Fundamental Rights of the European Union. This is for countries of Europe. Concerning the second question, whether it is possible to impose the death penalty without causing severe and physical pain or suffering, I would say that whatever answer is given to this question, even a positive answer, has to do with the way of implementing death penalty, which is of course also important, very important, but not with the death penalty itself. If it is possible to impose the death penalty without causing severe physical pain, should we retain it? As for the third question, whether the death penalty is respectful of the inherent dignity of the human person, I would say the following. Those who torture or are in favor of torture, those who defend the death penalty or who sign the decision to put someone to death, or those who use their vote in favor of using the death penalty against a criminal with different justifications, are not respectful of human dignity, yet of their own human dignity, which they share with the criminal. We protect or give damage to human dignity, our own human dignity, by what we do, and not by what we suffer. This is why my suggestions will be to revise our relevant instruments. They are not holy scripts, so as to close the door to the possibility of defending the death penalty as an issue of domestic criminal law, as certain states claim. And secondly, to better promote the ethical education of human rights in general, and within this framework, the abolishment of death penalty at all levels of education and in the media, especially in countries that still retain death penalty. Thank you for your kind attention.
Thank you, Madam, for your clear and articulate argument. I'm sure it has given us quite some food for thought for the upcoming discussion. But before that, Nicolas, over to you. What is the role of civil society in this issue? What has the civil society done or can contribute to?
Thank you. And first of all, please excuse me for my typically French accent, but I'm sure I will make it. I would like to start off by thanking the organizer of this event for inviting me to speak today as the program director of the French organization Ensemble, contre la paine de mort, together against the death penalty, ECPM. Before proceeding, please allow me a few minutes to present the actions of my organization, ECPM. Since the year 2000, ECPM fights for the universal abolition of the death penalty. As a unifying force of global civil society, we created a world coalition against the death penalty in the year 2002. Today, the World Coalition is a global platform of 200 NGOs, bar associations, unions, and local communities from the 5 continents. Every 3 years, ECPM organizes a World Congress against the death penalty, which brings together thousands of people, including political representatives, NGOs, legal experts, former death row inmates, to develop future strategies. After Strasbourg in 2001, Montreal in 2004, Paris in 2007, and Geneva in 2010, 1,500 people from all over the world took part in the 5th World Congress against the death penalty in Madrid last year in June. This Congress was also attended by leading politicians from abolitionist and retentionist countries. Today, ECPM is the main partner of the states for a coordinated action. ECPM is the coordinator of the informal core group, made up of 9 member states that call upon their diplomatic services to support abolition and the World Congress. In the field, ECPM helps abolitionist actors by promoting the creation of national and regional coalition against the death penalty. Today we are particularly involved in the MENA region and in Central Africa. Concerning the topic of the roundtable, the relation between torture and the death penalty, I will have one comment. Today, from the international perspective law, cutting a hand is not acceptable, but cutting a head is. Today, from the international law perspective, torture is not an option, but death penalty is. For ECPM, for all the global movements, it is a real contradiction. It is obvious that torture is a slow, a brutal, a merciless, it is obvious that death penalty is a slow, brutal, and merciless torture. I can give you 3 main reasons. First reason, the way to kill. Today, everybody recognizes that there is no human way to kill someone. Historically, death penalty was about making someone suffer, and that suffering was usually exposed to the public to set an example. Thanks to the human rights movement, some countries want to resort to an execution method that is clean, fast, and effective. For example, USA replaced the electric chair by the lethal injection. So, what is this more human method, lethal injection? The process includes a successive injection of 3 products. First product, the sodium thiopental, which is used for anesthesia. Second product, pancuronium, which paralyzes muscles. Third product, potassium chloride, which causes cardiac arrest. For information, putting potassium chloride in the vein is so painful that it does not allow by the American veterinary standards. Moreover, depending on the person, the process can be extremely slow. In 2006, the execution of the American Joseph Clark lasts 90 minutes, as long as a football game. So it is obvious there is no human way to kill someone. None of the 6 execution methods still used nowadays, guaranteeing to a peaceful days. Second reason, the prison condition on death row. Today, death row inmates have worse living conditions than the rest of the prison population. ECPM regularly conducts reports on death row, which shows that the treatment of death row prisoners could be qualified as torture. For example, in Morocco, our reports shows that because of the prison condition, more than 80% of the death row inmates suffer from mental illness. In Tunisia, the report shows many cases of violence and torture during the prisoners' incarceration. In DRC, Republic Democratic in Congo, the report shows that there is many prisoners suffering from AIDS and that do not receive medical care. Third reason, the amazing weight in death row. In most countries, the rate on death row can last between 20 and 30 years. Ahmed in Morocco, sentenced to death for political reason in 1984, was freed after 15 years in prison. In Japan, last week, Mr. Hakamanda was freed after 47 years in prison. 47 years. Because the appeals courts had suddenly doubt about his case. 47 years in prison. In Japan, it is important to note that in Japan, prisoners never know in advance when they will be executed. The day of the execution, the guards do not wear the same boots as they usually wear, so the noise that they make and the step sound are different. When the prisoner hears this very particular noise, they know that an execution is going to take place. It may be their turn, it may be their cellmate's turn. For all these reasons, it is obvious that the death penalty is a real torture. Every day, ECPM fights alongside human rights activists, lawyers and judges to help shape the public opinion and convince international organizations. During the World Congress Against the Death Penalty, an important place is always dedicated to the testimonies of former death row inmates and their family, where they talk about the hell of death row. Every day, ECPM fights to show the entire world that the death penalty is a violation of the human dignity. With our report on death row in Central Africa, in USA, in MENA region, and soon in Asia, we describe the horror of death row, a place where death row inmates live outside international standards. Today, we are convinced that the time has come for international community to take responsibility. The death penalty is a torture and must be prohibited. As the former Minister of France, Robert Badinter, said, like torture, the death penalty is bound to disappear from all justice systems. Thank you.
Thank you, Nicolas. Some powerful points for discussion emerging from your presentation as well. Council of Europe, it's a death penalty-free area, but it wasn't always like that. How did the Convention and the Court contribute to that? Childerik, please.
Thank you, Snezhana, and thank you to the organizers, the European Union, Andorra, Serbia, Norway, I believe, and Kazakhstan as well for bringing this panel together. I apologize on behalf of my colleagues back in Strasbourg from the Director General of Human Rights as well as the CPT who are unable to come and present this important issue themselves, but have put their trust in me to convey a few insights on indeed the evolution within the Council of Europe in terms of the death penalty, but also the linkage between torture and death penalty. At the risk of echoing Mr. Mendez, but it does provide context for this evolution, is that indeed that there appears to be a slow but nevertheless a very steady trend at the international level towards the abolition of death penalty, despite what current statistics actually reveal. As Amnesty International indeed has just concluded 2 weeks ago in its annual report on death sentences and executions for the year 2013, it's only a small number of countries who have actually triggered a spike, a global rise in the use of the death penalty. I'm afraid we can actually expect similar statistics for the year 2014, at least concerning the handing out of death sentences, given that in the same week in which the report was issued, an Egyptian court imposed a record number of 529 death sentences in a single day. It is to be hoped that none of them, of course, will be actually carried out. But such death penalty excesses by a very few states cannot change the fact that we see today a gradual but committed shift towards the abolition of capital punishment on a global level. I have indeed been asked by Snezhana today to talk about whether the death penalty amounts to torture or inhuman treatment and degrading treatment. And I will seek to answer this question indeed from the perspective of the European Convention on Human Rights. The Convention, as you know, is the oldest and most prominent human rights treaty of the Council of Europe, and is applied and interpreted, as you know, by the European Court of Human Rights. When the Council of Europe was actually created at the end of the Second World War, most European states still retained capital punishment. And when the European Convention on Human Rights was drafted in 1950, the death penalty was generally considered as a legitimate exception to the right to life, which is reflected in Article 2 of the Convention. But for several decades now, the Council of Europe has been one of the main driving forces behind the abolition of the death penalty in Europe. It crafted 2 international treaties which formed the backbone of the capital punishment abolition. Whereas Protocol number 6 to the European Convention on Human Rights prohibits the death penalty in times of peace, Protocol number 13 does so in all circumstances. In the past 17 years, indeed, Saint-Jacques was very right, no death sentence has been carried out on the territories of the 47 Council of Europe member states. This makes, indeed, the Council of Europe area a death penalty-free territory for its 800 million citizens. While we can therefore safely conclude that the death penalty is in violation of European human rights law, the question whether it violates Article 3 of the Convention, the prohibition of torture and inhuman and degrading treatment or punishment, is a bit more complex. While the answer today is definitely yes, it must be borne in mind that human rights law is not static, but subject to developments and changing conceptions. We can see this clearly with regard to the case law of the European Court of Human Rights in death penalty-related cases. Let me just explain. The European Court of Human Rights held in 1989 the case of Söring versus United Kingdom, which Mr. Mendez brought up yesterday in his keynote speech, that the extradition of a suspected murderer to the United States was against the Convention. It did, however, not come to that result because the applicant in that case was likely to have received the death penalty as such upon his extradition. In fact, the United Kingdom had not ratified Protocol number 6, and the court thought that the Convention had to be read as a whole. The prohibition of torture, therefore, had to be construed in harmony with the right to life in Article 2. The court rather found that the extradition would lead to the inhuman and degrading treatment because the applicant was likely to suffer from what was called the death row phenomenon. This phenomenon, which indeed describes the anxiety and psychological distress experienced by a person who was to wait for a long period for his or her execution, was considered by the court as inhuman and degrading treatment, contrary to Article 3 of the Convention. And as indeed Nicolas just mentioned, if you would ask the Japanese death row inmate Iwao Hakamada, after his 47 years of waiting for his execution, he would certainly agree with the court's finding. But we can also take from the Söring judgment that 25 years ago, the European Court was actually not yet prepared to find that the death penalty as such was inhuman and degrading treatment. Without the likelihood of the applicant being put on death row, the extradition would probably not have been considered to be in violation of the Convention at the time. The Söring judgment has become the leading case with regard to any extradition or expulsion situation in Europe in which applicants face a real risk of being subjected to treatment contrary to Articles 2 and 3, and it certainly had a great influence on the drafting of Article 19, paragraph 2 of the EU Charter of Fundamental Rights more than a decade later, which states that no one may be removed, expelled, or extradited to a state where there is a serious risk that he or she would be subjected to the death penalty, torture, or other inhuman or degrading treatment or punishment. Subsequent to the Söring judgment, the court found that a deportation to Iran with the possibility of the infliction of stoning for adultery would have violated Article 3 as well. Moreover, a number of extradition and expulsion cases concern diplomatic assurances given by the receiving country that a death penalty would not be imposed, which the court is only willing to accept after it is fully convinced that those assurances are credible. In 2005, the court considered in the famous Öcalan judgment that the imposition of the death penalty after an unfair trial violated both the right to life and amounted to inhuman and degrading treatment. However, it reached no firm conclusion then as to the question whether the imposition of the death penalty in general amounted to inhuman and degrading treatment. A quarter of a century after the Söring judgment, we can now conclude that this is the case if we look at the judgment of Al-Sadoun and Mufti versus the United Kingdom from the year 2010. This case concerned the transfer of 2 Iraqi nationals by the British authorities into Iraqi custody, which put them at the real risk of execution by hanging. The court found that all but 2 of Council of Europe member states had signed Protocol number 13, and all but 2 states which had signed had also ratified it. The court found that these numbers of ratifications demonstrated that Article 2 had been amended as to prohibit the death penalty in all circumstances. Even more important in our present context, the court held that the wording of the explicit exception for the death penalty in Article 2 no longer continued to act as a bar to its interpreting the words inhuman or degrading treatment or punishment in Article 3 as including the death penalty. We see therefore that the categorization of the death penalty as inhuman and degrading treatment very heavily depends on the number of ratifications of the protocol to a human rights treaty which seeks to abolish the death penalty. This is also why it is difficult to transfer this finding by the European Court of Human Rights into a more global context. The court was certainly not the only one to find that the death penalty amounted to inhuman and degrading treatment, given, for example, the South African Constitutional Court already came to this conclusion in 1995, and several Eastern European constitutional courts did so as well. Both the Inter-American Court of Human Rights and the US Supreme Court have found that mandatory death sentences without the possibility of discretion and consideration of mitigating circumstances amount to inhuman treatment. Moreover, it is now agreed in international law that the executions of persons with mental disabilities, pregnant women or juveniles would constitute inhuman treatment as well. And there are important voices at the global level, such as we have just heard from the United Nations Special Rapporteur on Torture, Mr. Mendez, who noted already in 2012 an evolving standard to generally consider the death penalty as inhuman treatment, and an increasingly changing perception of whether the death penalty is lawful in light of the United Nations Convention Against Torture. But if the United Nations the United Nations Human Rights Committee is not yet in a similar position to come to a result as the court did in the Al Sadoun judgment, it is because the International Covenant on Civil and Political Rights provides for a similar exception from the right to life for the death penalty. But its second optional protocol, which provides for the abolition of death penalty, has only been ratified by 78 states out of the 167 having ratified the Covenant. One possible answer to the question, how can we achieve this result also at the global level, is to encourage and convince as many states as possible to ratify the second optional protocol, and believe offering a substantial role for the civil society to push this forward. As this year marks the 25th anniversary of the adoption of that protocol, now is a good time to do this. Our Committee of Ministers in Strasbourg has done so in the past when debating the situation of the death penalty in Europe on a biannual basis. Moreover, raising support for the upcoming General Assembly resolution on a moratorium of the death penalty may help to form a new form of customary international law to prohibit capital punishment in all circumstances. A good starting point is to convince those states which are part of our organizations and still retain the death penalty. In the OSCE, 3 states, Kazakhstan, Russia, and Tajikistan, retain the death penalty in law, but have in place moratoriums on executions. 2 states, Belarus and United States, continue to impose the death penalty. The Council of Europe has repeatedly called on the United States, as well as Japan, as observer states to the Council of Europe, to put an end to this inhuman practice. The Council of Europe has indeed been seeing hopeful signs in the United States, not least a recent moratorium in the state of Washington this February. As to Belarus, the country remains the only European state that still carries out the capital punishment. The Council of Europe has been involved in various initiatives towards abolition in Belarus in the past and hopes that the country will join the moratorium on executions with a view to complete abolition. A few final words maybe on the Council of Europe's cooperation with other organizations towards the abolition of the death penalty. We are very happy today, of course, to participate in this side event, as we have done in previous OSCE meetings. The Council of Europe, of course, also cooperates with the European Union through the European Day Against Penalty, which is held every year on the 10th of October in connection with World Day Against Death Penalty. We also maintain very close relations with the civil society, and in particular the International Commission Against the Death Penalty and the World Coalition Against Death Penalty, by participating in their events and expert meetings to discuss possible steps towards universal abolition. We are well aware that all countries have their own cultures and traditions, which also affect their legal systems, and that the death penalty was at one time practiced in most countries of the world. We should thus be, I think, conscious that the process of abolition requires time. But every little step counts and adds up. And I believe that this snowball effect that we have achieved at the European level can also be achieved at the global scale. Thank you.
Thank you, Childerik, not only for this legal overview, but also for the positive note at the end. It shows nicely the evolutionary process, and I believe this is very much what Mr. Mendez was referring to in his speech as well. I would now like to seek views from the floor. Please, it's your turn. United States.
Thank you very much, Madam Moderator. And thanks to the panelists who have spoken today. We have prepared some points which I think most members in this room are familiar with, and we're happy to distribute those. But in the interests of time, rather than reading through those points, I would like to take those as presented and then make a few simple conceptual points. Today's session is on combating torture and abolishing the death penalty in the OSCE region. It is not that the death penalty is torture. It occurs to me that the focus, bringing many people to this room, is a desire to abolish the death penalty. That is, of course, a legitimate point of view. It's a debate that goes on not only in the globe, but within my own country. And the democratic systems that reflect the will of the people, in fact, reflect the ongoing debate about whether the death penalty should be abolished. But I would remind this group that we should be intellectually clear and conceptually clear about this discussion. We've heard about the death row phenomenon. We've heard about the stress and anxiety. We've heard about the difficulty of establishing means of execution that are clean, fast, and efficient. I'm guessing that people who are opposed to the death penalty would still be opposed to the death penalty even if those issues were addressed. And that's, again, a legitimate point of view with which I take no issue at present. But let's be honest, let's be clear about what we're discussing here. There have already been references to Articles 6 and 7 of the ICCPR, very welcome and clear ones. I would propose that with Article 6 explicitly providing for the death penalty in certain cases and Article 7 outlawing torture, the conclusion must be that the death penalty per se is not torture. Otherwise, these articles could not coexist. So what I would ask this group to do, I mean, I recognize we have an SHDIM on torture, and so that's an excuse to talk about things people don't like, and maybe also call them torture. But if this is a session not on torture, but on abolition of the death penalty, then let us have that discussion. Thank you.
Thank you, sir. Yes.
Thank you very much indeed, and I welcome this opportunity to be able to address this gathering. Let me introduce myself. My name is Malcolm Evans. I'm chair of the United Nations Subcommittee for the Prevention of Torture, and it's nice to have the opportunity at this point of addressing the meeting on this important topic. I do note the comments which have just been made by the representative from the United States. With respect, the actual title, as I have it on the list, is Supplementary Human Dimension Meeting on Prevention of Torture. And I think that this is one aspect that could usefully be brought into the discussion here as regards the question of the relationship between the torture, inhuman and degrading treatment and the death penalty. We look at convention obligations which exist. Reference has been made to Article 6 and Article 7 of the ICCPR. We've also, of course, heard how in the context of the European Convention on Human Rights, the relationship between Article 2 and Article 3 has come to be, shall we say, reconfigured in the light of the evolving understanding of what Article 3 could mean in the light of ratifications to its optional protocol. The point that I would merely wish to draw attention to in this discussion is that all OSCE participating states are, of course, a party to the UN Convention Against Torture, Article 2 of which does require states to take preventive measures as regards as regards the phenomenon of torture. And I think it at least deserves thought the extent to which introducing both moratoria and indeed prohibitions on the use of the death penalty may, in the light of the evolving information and evidence we have about its effect on people, reasonably and legitimately be seen and understood as a preventive obligation, even for those who find it difficult to interpret the prohibition on torture as extending to the death penalty itself for the reasons that have been given. In my own mind, I am at one with what the Special Rapporteur has got to say on this, but I do respect the debates which exist around this subject, but I do wonder whether focusing on the obligation to prevent torture, ill-human and degrading treatment and punishment, which all participating states are obliged to respect, might give an additional route into this discussion that might help address some of the concerns that have been raised about the interplay between Article 6 and Article 7 of the ICCPR. Thank you very much.
Thank you, Malcolm. Jamil.
Good morning. I'm Jamil Dakwar from the American Civil Liberties Union. I would like to comment on some of the remarks that were made by the panelists and other representatives. I think the first comment is really related to representative from the United States. I think the argument is that the methods of execution could amount to torture. And obviously, not all executions would amount to torture per se, otherwise they would be would be prohibited or outlawed. However, as the Special Rapporteur discusses in his report, and I think we need to discuss what he is suggesting, the methods of execution, the amount of suffering, severe pain, or could amount to severe pain or suffering that would really raise to the level that would constitute it as a torture method, including the death row phenomena and so forth. So I think the suggestion here is not to go into the debate now whether it's per se. I think there's an evolving consensus towards the abolition, towards seeing the death penalty as per se, but it's still, he was very clear on that. And I think I would suggest that we basically try to respond to what he found in his report. But I also wanted to come back to some of the essential facts of the status of the death penalty in the United States, because I think while we are discussing the prevention of torture, it has to be seen in the context of other parameters or other factors that contribute to the fact that the torture, that the death penalty would be in a position that would be seen as a violation of international law, and particularly one that relates to the issue of the way it is practiced, particularly the discriminatory fashion, in the discriminatory way that it's being applied, particularly in the United States context. The one thing, though, that is important to note, that the executions in the United States are on decline, and that's actually a welcome development. In fact, only 9 states carried out a total of 39 executions in 2013, most of which took place in Florida, the states of Florida and Texas. In February 2014, as was noted earlier, the governor of the state of Washington issued a moratorium of the use of the death penalty, and the state legislature of the state of New Hampshire is very close to repealing the penalty. However, despite these encouraging national trends, there have been troubling developments in some jurisdictions, and I want to highlight some that really relate to the issue of prevention of torture, particularly as it relates to the use of lethal drugs that are not transparent. For example, in a number of jurisdictions, because of the shortage of drugs to use in lethal injunction procedures, state departments of correction have been experimenting with new methods of execution. For example, in January of this year, Ohio, the state of Ohio, used a new untested method to execute Dennis McGuire. It took nearly 25 minutes for Mr. McGuire to die. And witnesses described him gasping for air and breathing for up to 15 minutes. Several states are now seeking, in the United States, are seeking to return to former methods of execution, like the firing squad and electric chair. I think it's very important to address this issue which I think that the Special Rapporteur concluded, to what extent the death penalty is worth investing in when the results are not only discriminatory, violate due process in many jurisdictions. There have been 144 exonerations in the United States alone. People were exonerated. The last case of exoneration happened just last month in the case of Mr. Ford in Louisiana, after spending 30 years on death row in the state of Louisiana. Now, if we take all of this as a whole, I think we come to the conclusion that it's worth revisiting and seriously taking steps in order to impose a moratorium on death penalty. Now, in the US context, the federal system makes it much harder for the federal government to take action in order to end the death penalty in different states. However, we think that the federal government can actually take steps such as imposing moratorium on the use of the death penalty in federal cases. There is no criminal obligatory law that says that death penalty would be mandatory. And yet, in the last case, terrorism case of the marathon bomber in Boston, Mr. Holder, the Attorney General, sought the death penalty. We think there are other measures, and we can provide more information. I just want to make sure that there are, while we think that it's a matter for states to take their democratic process and actions at the legislature's level, as is happening in a number of states, the federal government should also take the lead on addressing the different problematic use of the death penalty, including some cases that go before the Inter-American Commission on Human Rights. Precautionary measures are issued in those cases, calling for suspension of execution, and yet those executions move forward. The last case of Mr. Edgar Tamayo, from Mexican national, who was on death row in Texas, and his execution in January of this year in violation of international law and treaty obligations, the Vienna Convention on Consular Relations, is one example of where it has become not only a matter of fundamental human rights, it's a matter of international relations, international law, and respect for these fundamental diplomatic relations between countries as well. Thank you.
Thank you. Any other interventions from the floor? Then can I turn Please, the United States.
Thank you. I'm sorry to come in a second time, but in light of some of the comments made, it's clear that my attempt at brevity by not going through some of our talking points that those who are resident in Vienna are very familiar with has perhaps been frustrated. So I will very, very quickly go through some of the points with respect to the application of capital punishment in the United States. U.S. constitutional restraints, federal and state laws, and government practices limit the ability to impose the death penalty of the most serious offenses, as authorized under ICCPR, Article 6. These prohibit racially discriminatory imposition of the death penalty, require that sentencing decisions be individualized to the particular offender and offense, and prohibit the use of any method of execution that would inflict cruel and unusual punishment. Additionally, the U.S. has a free and independent judiciary, which frequently considers issues related. Recent rulings by the U.S. Supreme Court now prohibit the imposition of the death penalty from offenders under the age of 18, mentally retarded offenders, and non-homicide offenses against individuals. These laws and the U.S. judicial system provide an exhaustive system of protections at both the state and federal levels. Again, I'll be happy to make these points available for distribution. I'm pleased that there seems to be an implicit recognition in the room that the discussion is now turning toward the death penalty as such, rather than conflating issues of torture and all versions of the death penalty. We believe that the ICCPR is quite clear in that regard. Thank you.
Thank you, sir. Can I then turn to our panelists for maybe some final remarks on the basis of the discussions? No more than perhaps 2 minutes, also because we have to vacate the room a couple of minutes before 10, because there will be a meeting here and we have to be downstairs, of course. Madam Kuçuradi.
Thank you. I always wonder why you look at death penalty only as a legal issue. All the discussions are made on this basis here. The right to life is an ethical right. Human rights are ethical principles. We forget that and we deal with them only as law. And so long as we do that, we cannot face all these legal questions. I think that it would be better than legal acrobatics to go to the core of the thing. Is it violation of the right to life or not? Death penalty. Is there anybody who will say it is not? I am asking you. Is there anybody who will say the death penalty is not violation of the right to life? Thank you.
Thank you. No?
Yes, thank you, Snežana. Maybe in terms of summarizing the presentation I've made, I think that the link between inhuman degrading treatment or torture towards death penalty is largely mute, in a sense that the Council of Europe has now basically established that death penalty as such, as a principle, is an infraction to the right to life. So the question doesn't even pose itself. It's basically irrelevant. However, it has played a role in the perception, the popular perception, the legal perception over the past decades, leading finally to a clear abolition of death penalty. And again, echoing Mr. Mendez, even if the legal space is restricting around the use of death penalty, the different exceptions, the inhuman degrading treatment, juveniles, pregnant women, and so on, the method of execution is restricting the space of death penalty, can be seen as welcoming, as a positive development in diminishing the use of death penalty. I would actually agree with İoanna, of course, that rather than going through all these legal artifices, to be able to actually go to the core, to the principle that death penalty as such is simply wrong. Thank you.
Thank you, Childerik. Thank you to the panelists and thank you to the interveners. We've had a short time to discuss a critical issue, but we've had a vigorous discussion and I am grateful to you for that. Clearly, we have differing views in the OSCE area, although a certain consensus seems to be emerging. But then again, we are intertwining a little bit the argument here. Are we discussing abolition or are we discussing torture? Probably the emerging consensus is towards the abolition, also looking at the numbers in the OSCE area. The very critical question of whether certain execution methods constitute torture has been discussed and argued very strongly here. This debate needs to continue also within the OSCE framework. I would encourage you all to look at it again, perhaps in the context of the Human Dimension implementation meeting, which provides another such opportunity both in the plenary session and also by way of such side events which are attached to the mandated events but are not part of them or part of those official discussions. I think we are perhaps leaving with more questions than answers. Perhaps not, but it's good, and I thank you all for your participation, and I hope to see you then downstairs in about 10 minutes' time for the second working session of the Supplementary Human Dimension meeting. Thank you.